Hi everyone, this is Hamida. Welcome to Surfy Law channel. Today we will discuss about the various important questions relating to the DPC Viva. First one, what is meaning of the DPC? DPC is nothing but drafting, pleading and conveyancing. Now, what is drafting? Drafting means what? Drafting is nothing but it is the legal written statement. Drafting is nothing but legal written statements. So we have various essential elements are there when while drafting of every legal document. Legal documents means what? Various legal documents are there, like agreements, drafting of the various agreements, drafting of contract, drafting of various pleadings, drafting of deeds. So those all are the things which is comes under the drafting only. Drafting is the written writing of some statement relating to the particular knowledge about the particular case, particular facts of the case, or the particular related to the property. So all those things which is comes under the relating to the facts drafted in the particular document. Now we will go to the various essentials of the drafting. Here we have the various essential elements of the drafting, that is the precision, clarity, lucidity and adaptability. Precision means what? While drafting of every document, we should have to write clearly, accurately, exactly. Suppose if you want to write about the particular related X property, then you have to be that exact whatever you want to express in that particular document, what we want to show in that particular document. Second one, it is that right, clarity. We should have to be clear about the particular statement of the facts. Means whatever that facts we want to be described in that document, we should clear about it. We should clearly describe about it. Now going to that adaptability. Whatever that the statement we should mention in that particular document, it should be adaptable. It should be changeable. It should be amendable. Means it should be easily amended. It should be clearly altered to that particular document. So these all are the essential element. Along with that, lucidity is also one of the essential element of the drafting. Lucidity in the sense what? Simply and every person can understand. In the sense, drafting in the sense what? Every document we should write clearly without any ambiguity, and that document should write in simple language, not to use that like a British language or to the American language. We don't need to be right about to the particular language should have to be maintained. We should have to be clear about what we want to express to the people, what we want to express to the particular parties. So those things we should maintain while drafting of each and every legal document. Now we can we'll go to the next one, next question. It is relating to the important question in the DPC, that is the pleading means what. Here we have completed the drafting. Drafting should be clear and precise, clarity without any ambiguity. Everything we should maintain while drafting of each and every document, whether it may be a pleading, whether it may be a legal document or deeds or agreement. So we should maintain all those essential elements. Second one, pleading means what? Pleading in the sense it is nothing but before the trial part, whatever the process is going on is called the pleading. So here, whatever the process before the trial means what? Making of the plaint or the written statement. So these all are the things which is comes under the pleading. Pleading here we have the civil pleadings also with the criminal pleadings also be there. In the civil pleadings means a person in the parties has to be write the plaint copy, written statement. Those all are the things which comes under the civil related cases. So here what are the essentials of the pleading? This is pleading shall contain the statement in the concise form. So, pleading, while drafting of the plain copy or any written statement or any other statements relating to the particular case, we should have to be writing concisely, precisely, shortly. Then, next one, pleading should contain only the facts of the case. So, we have to write only the facts of the case, not to write any legislation, not to write any related any sections or the articles related to the particular case. Suppose if I want to write about the property related case, I want to ask the relief to the court is relating to the property or the specific performance of the property or any kind of related property cases, I just have to ask about the write about the facts of the case, but not to mention about the any sections or any evidences or any articles. We don't have to be mentioned while writing of the any pleading. That one we can see in the argumentation or the court will see. But it is not while writing of the plain copy, while writing of the written statement, we don't have to be mention any of the sections, articles, or acts, or any legislation. Only we have to be write or mention about the facts of the case. Or also, pleading can be amended or altered with the permission of the court. So here the pleadings, every pleadings can alter or amended. And that one only happen after the permission of the court. How can we take the permission? We can take the permission by giving the application or by giving of any affidavit. If the court satisfied, then only we can alter the particular pleading. But one thing we have to be remember, if we want to get the relief and relaxation, if we want to give a more value to the particular plane, we have to describe each and everything in the first part only, not to alter. Means alter we can do it, but that much value is not there when we describe primarily only. Now, here, yeah, we know that the pleadings in the sense of both the parties has to be signed along with the advocate, along with the pleader. Pleader in the sense what? Advocates. Means here that both the parties have to be signed to the particular document. In the sense the plaintiff party, defendant party, along with the advocate, every person's signature is mandatory while filing of the every pleadings in the court. Now we will go to the discuss the plain and essential elements of the plaint. Discuss plaint and essential elements of the plaint. So now we know that I said about the pleading in the sense what before that trial part, whatever the process is going on is called the pleading. Means I said that the plaint is also comes under the pleading. Written statement is also comes under the pleading. Now what is the plaint? Plaint, it is the initiating to the suit. I mean, it is the initial part of the suit. First, that means it is what the plaintiff party, this is the aggrieved party, which gives the memo to the court. Means, first relating to the relief, whatever the relaxation they want, they urge to the court relating the particular facts of the case. Now, plain, what are the essentials of the here the rule 1 to 8 of order 7 of the CPC provide the various essentials is relating to the plain. First, the name of the court in which the suit is brought. The name of the court. First, here that the plain copy has divided into the three parts, a few of the parts. That is the title part. Next one is the party's description part. Next one is the facts of the case, cause of action. Next is jurisdiction, limitation, verification, prayer. So these all are the things we have to be mentioned while drafting of the plaint. So first thing, the title. So where, in which court we are going to file the suit? In which court we are going to the file a particular related case. Suppose if it is relating to the civil related case, so we have to approach to the civil courts. If it is relating to the criminal related, we know that in every, whether it may be the civil related is related to the plain or to the criminal related cases, or whether it may be the complaint or whatever it may be, we have to be use the title. It is a very important thing. Title in the sense in which court we are going to file. In which court we are going to file. Suppose if it's civil related cases, plaint civil related cases, while drafting of the plaint, we have to mention about the civil courts where we are going to file that particular civil related cases. Suppose if it is senior civil court or a city civil court or junior civil court, or wherever we are going to file in this court, that one we have to mention. And that one is also depends upon that court, also depends upon the facts of the case. So if the facts of the case which is supports to that, suppose if it is relating to the jurisdiction, territorial jurisdiction, the pecuniary jurisdiction, if it is that jurisdiction, pecuniary jurisdiction, that the court relates lower value, that means the case is a lower value, then we can approach to the junior court. If it is more than that, then we can approach the senior courts. So like that, we can divide the jurisdiction of the court and we can approach the particular courts. Okay, so here the title of the court which is depends upon to the facts of the case only. Okay, next one, it is the description and place of the residence of the plaintiff. So here, the first one, it is the title of the court where we are going to file. Then that next one, it is the person who the aggrieved party, in the sense the plaintiff party, description of the plaintiff party, residence, occupation, name, everything you have to describe about to the particular party. Next one, and in between that, to whom you are going to file, means first the party who is going to file, that is the plaintiff party, to whom we are going to file, this is defendant party. The second, it is the description part of the defendant, everything you have to be described while drafting of the plaintiff copy. That is the next one, it is the yeah, if it is relating to the minor or to the unsound mind, a statement to the effect. So here, if it is relating to the minor or to the unsound mind person, you should have to be clear about it. Suppose if you want to transfer the minor's property to the third party, then you have to write, describe about to the minor why the guardian is going to transfer the property to the third party. Is what is the reason to transfer that particular property to the third party, whether it is a beneficiary for that minor or whether it is the beneficiary for the unsound mind, everything you have to be clear about it while describing about the unsound mind person or to the minor, or along with that guardians also. So here, first that the title of the court, next one descriptions of the parties, in the sense plaintiff description, defendant description, if it is relating to the minor or to the unsound mind, you have to describe every person's complete information, just as residence, name and address, everything you have to be describe it. Next one, yeah, here the facts constituting the cause of action and when it arose. Yeah, then later on you have to be right about the facts of the case, what happened, and that one also what we have discussed in the drafting, precisely, concisely, clearly, without any ambiguity, and you should maintain the chronological order. You should maintain the chronological order. This is what one para is. So it's means the both the paras have to be give some meaning. Suppose if you are writing in one para, it's relating to the one case, and another para you have to write about this connecting to the first para. So here both the paras, means both that information is connecting to the each another paras. So here you should have to be write clearly with the chronological order and everything precisely, shortly, with the simple words you have to try to give the information to the court. Next one, cause of action. Cause of action means what? It is that when the cause happened, when the cause arose, when the cause, in the sense when the injury happened, when the party with the witness injury, in the sense what is relating to the any harm, any injury or any damage, whatever it may be, when the injury happened, those things also you have to be described. Okay, along with that, what that relief the plaintiff want, what the relief they want, what the means suppose if they want to get that specific performance of the property or specific or if if the plaintiff wants the restitution of the conjugal rights, so everything you have to be briefly urged to the court, means this is comes under the prayer. Before that, you have to be right about the limitation period, when the cause of action happened, when the person who is going to suffer, all those things they have to be described while drafting of the plain copy. Along with that, verification, so this verification also, along with that, whatever the documents it is necessary, that one also you have to be produced in the court. So this is